presentation on mining disputes in Africa, in particular under the theme, what you need to know to protect your investment. So we have attendees and people who've registered over, I must say, 17 plus countries. So we're very happy that we've had an overwhelming correspondence. So we do expect that a lot more people will join us as we go on. My name is Joseph Jalasi. To start the introductions, I am head of mining for Dentons Africa, but I'm also partner for the Zambia office. I'll get to the intros of our distinguished guests who will be presenting during this webinar. But before I do that, just want to have a few housekeeping issues taken care of as we go in. Please, whenever, if it's possible, please, we would love to see you. It would be great if you could switch on your cameras. I think from my experience, it always makes these sessions much more engaging than staring at some initials on the screen. And then secondly, I would request that everybody who is not speaking, we've got our team behind Khalil, Cham, and Mika to make sure that you mute everyone. But please, my request is, could you just look at your mic and make sure that it is on mute? Otherwise, those background noises disturb the flow of the conversation. In terms of questions, please, as the presenters are speaking, you are at liberty to pop your questions in the chat function. Sorry, I'm getting some feedback. Hamal? Okay, is it Ishmael? Could you please put your mic on mute? Thank you. I was saying that please utilize the chat function for questions that you may have as the speakers are speaking. Then we'll do our best to get these across to the speakers so that they can answer those questions. If we are unable to address any of those questions, of course, we've got the speakers, their contact addresses. We'll send them to the speakers, and we'll have your email addresses, and we'll be able to get back to you. In terms of introductions, I think I'll get into it. We have on the panel, initially, those of you who looked at the banner, you know that we've got James Langley from the Dentons UK office. He is partner there. We have Diora Ziyaeva, who is partner and lead mining for the Dentons US core mining for the Dentons US office. And then we've got Natasha Paray, who is the partner in the Mauritius office. Then we also have, by way of a special guest, Lawrence Tay from our Singapore office, who, although he doesn't appear on the banner, we decided to ask him to hop in and make a little surprise for us and the presentation. So these will be the main speakers. In terms of sequence, we'll start with Natasha from Mauritius, Diora from our US office, and then finally wrapping it up will be James. In terms of questions, we'll flow through this through each presentation by the speaker. But like I said, please feel free to utilize the chat function. So to kick this off, since we just have 1 hour and we have a loaded 1 hour packed, I'll call upon Lawrence Tai from our Singapore office just to introduce the Dentons Global International Arbitration Practice. Although he is based in Singapore, he's currently in Johannesburg, and we invited him just to spend a few minutes, give an overview before we get to Natasha to give us the bit of the overview of mining disputes, and before I go into the introduction of the general mining practice overview in Africa. So Lawrence, please, over to you to give us some remarks on the Dentons Global Arbitration Practice. Lawrence?
Thank you very much, Joseph, and good afternoon or good day to everyone who's joining us. I'm Lawrence Tay. I'm based in Singapore, but together with Anna Crevon, I look after the global arbitration practice of Dentons. By happy coincidence, I happen to be in the Johannesburg office, and it was thought that I should appear very briefly in this webinar just to introduce the international arbitration practice. We have a global steering group of about more than 50 lawyers whose work substantially involves international arbitration. Anna and I did a count of the number of lawyers globally we have whose work involves arbitration to a greater or lesser extent. And in our estimation, that's about more than 500 in the world. The Dentons international arbitration practice is one of the best practices in the world. We are ranked among the best 20 firms each year. And our track record speaks for itself, whether you're looking at billion-dollar cases or substantial cases that go to long hearing. We have a very, very wide breadth of experience, ranging from commercial arbitration through to investor-state arbitration. We also have a great geographical reach. We are in all the major arbitral seats in the world: London, Paris, New York, Singapore, Hong Kong, just to name a few. And of course, very much in the energy and mining space. That's what I wanted to say. Other than that, your speakers today, James, Natasha, Diora, they are all part of our global steering group. So with that introduction, I would like to leave proceedings to the speakers. I might pop in and out of this webinar, but I'm running a very urgent freezing injunction in Singapore. But let me commend this event to you and wish you a very successful meeting. Thank you.
Thank you very much, Lawrence, for introducing the Dentons global arbitration practice, which is wide, and part of the speakers here are part of that practice. And thanks for showcasing the depth of what we have. So I'll give a quick overview just before we get into the meat of the webinar. Dentons in Africa covers a number of countries. We are in South Africa, Zambia, DRC, Tanzania, Nigeria, Morocco, Mozambique, Ethiopia, Senegal, and Namibia. All of these teams in these countries have got the depth and are able to represent in various disputes, whether they be in mining, investment, etc. So as you can see, the map there gives you a wide geographical spread, and it shows the true wide expanse of the Pan-African frame that Dentons is. And I can say that I think you can look out for further announcements in the course of the year. We should be opening in more jurisdictions in West Africa and Central Africa. Next slide, please. The key contacts that we have are up on the screen. We have No Capti, Tommy from South Africa, Tommy from our Cameroon office, Patty from the DRC office, Andrew from Kenya, Omar from our Morocco office, Reginaldo from our Mozambique office, Taiwo from the Nigeria office, Thomas from Tanzania, Tamrat from the Ethiopia office, Nidal from Senegal, David from our Uganda office, and of course we have our own Robin Modumuto, who runs the Mauritius office. So as you can see, it is a detailed and very spread out, and I must say, very able team that is able to assist. So taking advantage of this platform, I thought as the Africa lead for mining, I could just give an overview of what Dentons in Africa looks like and your key contact person. Of course, if you need any details in terms of getting in touch and can't remember some of the faces that you saw flash by your screen, please feel free to contact myself. I'll avail details of my email later on in the chat. So with that said, I would like to invite Natasha Paray from our Mauritius office. To begin this presentation on the overview of mining disputes and arbitration trends in Africa. Natasha, over to you. Thank you.
Thank you so much, Joseph. So, hi, everybody. Now, you might be asking yourself, and quite legitimately, what does a Mauritian partner, a UK partner, and a US partner have to teach you about political risk mitigation in Africa, which is basically the jurisdiction that you are concerned with, where you are present every day, you are occupying the ground every day, and you might have much more knowledge of what's happening on the ground than any of us. Well, the idea behind our training session today is to cover an area of law that perhaps as domestic law practitioners we often overlook. And when we have an issue which arises in respect of our client's investment, we are not fully equipped with whatever strategies or mechanisms that may be available to provide real assistance to the investors. So we are here talking today about dealing with political risk from an international law perspective. Now, why do we need international law? A very brief summary of how investor protection under international law came about. So there was a time when investors investing into foreign jurisdictions, that is jurisdictions of which they are not a national, were concerned with one major question. They were not the people who were electing the government, but they were ultimately the ones who were subject to changes in the law that had the potential of affecting their investment. Now, if their only recourse was under the domestic law of that jurisdiction, that law was subject to change, which meant that by a simple legislative instrument, they could be deprived of certain protections or the benefit of their investment. Now, recognizing that this was a real issue and that foreign investors do not have a say into electing who governs the country where they have invested, the international law community came about with a method of protection of foreign investors, which is based on international law. But even though at the inception of that protection mechanism, we were relying on customary principles of international law, which are not very substantive in their content, with time and in order to facilitate international investments, states started entering into bilateral or multilateral regional treaties to grant more protection to investors. And this is what we tend to call investment protection and promotion agreements in Africa, or bilateral investment treaties in the whole wide world. Now, in Africa, in addition to bilateral investment treaties between two countries, two states, that is the state that would typically send investment into Africa and the state that receives the investment, there are also, and we will see in a while, some regional treaties that tend to protect investment. So what we are talking about today is that layer of protection which exists beyond domestic law. And because it is a matter of treaty protection, the level at which the governments of our respective states can intervene to change the content of that protection is different. And we will see in a while what this means for the mining sector. Now, Joseph had put on a very interesting slide at the beginning to show how mining is an important component of the economies in Africa. And when you do a basic search on Google, you will see that we export 75% of the world's global diamond quota. We have a very rich developing critical minerals resources practice. And these are things that naturally attract investors. But one question that we need to ask ourselves is why, even though Africa has been the promised land of investment for many years now, it has been at least 3 decades that Africa has been flaunted as the next thing to happen, but investment flows into Africa remain very, very shy, even though it's increasing, but the rate of increase remains a subject of concern. And when we approach foreign investors to ask why that is the case, the reason that is given is more often than not political risk, that the political political climates on the African continent is so subject to change that they are any risk averse investor would be concerned to invest in the jurisdiction. So there is a mismatch between the opportunity and realization of that opportunity, which we can reckon with as lawyers, or we can help our clients manage in a bid to increase their confidence in the African continent. Now, that issue of political stability or the risk that is inherent in any foreign investment is not an issue which is confined to the African continent, but perhaps unfairly, it is the one thing that is glaring when we speak about Africa. And our value resides in recognizing that and allowing investors to understand how their investment can be protected, so that if they come here, they have some measure of reassurance that they are not going to be subject to coercive government action that reduces the value of their investment. And the way we do that is because there are bilateral investment treaties between different countries, and each bilateral investment treaty can provide with different levels of protection, different standards of protection. The content of each treaty is different. The country or the jurisdiction from which you anchor your investment to come into Africa may give you a different type or level of protection compared to another jurisdiction where you decide to park your investment to then invest into Africa. So understanding the content of those treaties is very important. Now, can I have the next slide, please? Right. So if we have a look, for example, at the treaties signed by Mauritius, the ones that are ratified and the ones that are awaiting ratification, for instance, you would see that we do cover a number of jurisdictions. But if we have a look at the Mauritius-Cameroon Treaty and the Mauritius-Kenya Treaty, the content will be different in terms of who is protected, what kind of protection you have, and what kind of recourses you have once there is an issue with your investment. Now, why do we talk about the recourse? It's because, again, just like Africa has a bad name for political instability, we also have a bad name in terms of the level of confidence that people have in our court systems. Now, if, for example, the government of Mauritius does something against your investment and expropriates your property, there is a sort of fear in the mind of investors that if they do seek recourse from the Mauritian courts, they might not win the day because of perhaps an illegitimate fear of corruption or favoritism for the government, so that courts in our local jurisdictions are not seen as a viable option. And those bilateral investment treaties give us another recourse by way of arbitration, where we can invoke the protection, the treaties, the standards of protection granted under those treaties that Diora is going to expose to you, and ensure the investor that at the end of the day, his investment is going to be protected. Now, can I have the next slide, please? In addition to the bilateral treaties that we have just seen, within Africa, we have something that is up and coming and that we need to have a look at. And that's the African Continental Free Trade Agreement and the protocol thereto and the annex to the protocol. So if the African Continental Free Trade Agreement comes into force, it will have the effect of cancelling all intra-Africa bilateral investment treaties and replace them by one single treaty which will be applicable to that whole area, which means that in a near future, possibly, if that treaty comes into force, we won't have to refer to different instruments for intra-Africa investments, for example, investments from, let's say, South Africa to Libya, but we would still have bilateral investment treaties, let's say, from Europe to Africa. So the AFCFTA is something that we need to watch out for. And one of the main reasons why we need to watch out for is that even though the protocol has been drafted and is out for signature and ratification, the annex to the protocol has not yet been drafted. And the annex to the protocol will contain the dispute resolution mechanism, which is available to investors if ever their investments is at risk. And word in the corridor is that there is a chance that arbitration is not going to form part of the dispute resolution mechanism, which may have effects on whether investors can safely choose to invest from one African jurisdiction to another African jurisdiction. But this is something that which is up and coming, and it's not really topical yet, but I just thought I would mention it so that you keep an eye on it. Can I have the next slide, please? Now, in addition to the AFCFTA, we also have the COMESA agreement, which contains certain guarantees, for example, against expropriation, and which provides for compensation against expropriation. But what we need to know is that even if this treaty was not in force, expropriation is something for which there exists protection under even customary international law. But the issue is that without a treaty, you wouldn't be able to go, for example, to arbitration, and you would have had to seek recourse elsewhere, including through diplomatic protection. Can I have the next slide, please? Yeah, so here you can see a patchwork. You can, in respect to the same countries, have different instruments that provide for protection. So in addition to COMESA and individual investment protection and promotion agreements, you would have the AFCFTA treaties and other sorts of regional instruments that could provide protection. So the point we're trying to drive here is that when you have a foreign investor who has invested in your jurisdiction and has an issue with his investment, when we are talking about mining, for example, one of the most common issues that we have had to face, especially recently, and we have seen the example in Burundi recently, that when a new government takes over, they tend to seek to nationalize resources and take over mining quarries and exploit it. Now, if that quarry was being exploited by a foreign investor who's already invested heavily into that property, the issue is then what can you do against the government? Your first, the automatic reaction from any domestic practitioner would be, well, what is the recourse under domestic law? How can we sue government under the domestic law? Now, the idea that we are trying to put forward and promote here is that there are protections as well that exist at the international law level, which can provide effective protection. But to avail that protection, you need to be able to advise your client on where to structure or where to park the investment at the outset when they are making the decision to invest. Now, the best time when to decide from which jurisdiction to park your investment would be when you're starting the project and when you are, for the first time, considering, for example, entering into a concession agreement with a government for the exploitation of diamonds, for instance. But that doesn't mean that if you have wrongly structured at the outset, you can't change the country of your from which you invest. That process of investment relocation can happen at any point in time until and unless a dispute has arisen. So there is nothing preventing an investor from changing his host state from, for example, Mauritius to, for example, South Africa, if South Africa has better treaty protection with the country where the investor has invested. For example, if somebody is investing into Tanzania and the Mauritius-Tanzanian BIT is not as strong as the South Africa-Tanzania BIT, you can, for example, advise your client to relocate the investment from Mauritius to South Africa so that he benefits from the treaty protection. And this can be done until and unless the government has actually taken action to expropriate property or to do anything that would devalue the investment, for example, impose extortionate rates of tax that take away all your profits. So the decision of where to structure your investment from can either be taken at the outset, which is the best time to do it, or at any point in time until unless the issue arises. And this possibility has been recognized under international law, which states that you can have a treaty planning, but you can't treaty shop. So once the problem has arisen, the government has already announced that it is cancelling your mining lease. You cannot then change the investment to benefit from a treaty protection. So this is a quick run through about what how Africa is protected under international law and how we can assist our clients, including in the mining industry, from deciding where to invest from to grant the maximum protection to their investment. That's it for me, unless you've got any questions for me at this stage.
Yeah, sure. That's actually absolutely important. Just a couple of questions, Natasha, which crossed my mind as you were presenting. What would you say are the common triggers for mining disputes in Africa from your experience?
The two most common ones that we have seen and that form the majority of disputes between investors and states in Africa is firstly the resource nationalism, so the decision of the government to take over any resource or exploitation of any resource in a country. And secondly, it's the cancellation of leases. For example, if I take a mining contract and give it from company X to company Y on purely political grounds once the government changes. So these are the two main ones that we see, especially in the mining industry. What we are forecasting will happen is that with global commitments focused on climate change and energy efficiency, etc., if there are moves by the government to impose higher rates of taxes on mining practices that are not energy efficient or that create a risk for the climate, those taxes can also be subject of contest before international arbitration, if ever they are extortionate. So this is something that is emerging, but that we haven't seen much of on the African continent for the time being.
Okay. And just flowing from that, we do know that and I think the transition from carbon-based fuel to electricity obviously puts focus in terms of certain minerals which are being called critical minerals. As a result of that push to for the world trying to access Africa's critical mineral resource, my question to you is: are you seeing any increase in arbitration related to this the green transition? I mean, on critical minerals and energy transmission, has it triggered an increase from what you're seeing?
The increase in cases has not yet hit Africa as it has other jurisdictions and other continents, but it is something that we can certainly hope, but it will all depend on policies that government adopt and what they decide to do for to incentivize investment into critical minerals compared to other minerals.
All right, thanks. I know William had his hand up. William, if you could put your hand in the chat, please, so that we can take it down, so that we can move on to Diora, due to the limited time that we have. If you could please just put your question in the chat, we see it. We'll be gladly to direct it to Natasha or Diora or James. Now, moving on to you, Diora. Diora is presenting on best practices for structuring investments for maximum protection. Diora, could I leave the floor to you and tell us from your wide experience how you can help investments and get them the maximum protection, given the risks and the reputation that Africa generally has in terms of investors worrying about protecting their assets. We do know what's going on in West Africa, the energy transition, putting pressure on those resources. So over to you, Diora.
Thank you very much, Joseph. It is a pleasure to be here. Thank you all for joining us. To continue where Natasha has helpfully left off during her presentation, truly flexibility is a kind of the strategic tool for political risk mitigation, because political risk is an inherent part of international investments. And Structural flexibility is a key to long-term protection. It enables quick adaptation to evolving political environments, and it helps safeguard assets and maintain operational continuity. So a lot of times what we see in practice is a general counsel, for example, of a longtime client of the firm comes in and says, look, I have a huge mess and it's in a really bad place. We invested millions and millions of dollars in a brand new mine in a developing country, or in any country, for the matter of fact. Things were going well, and then there was a coup d'etat, or things changed, and now we're left with nothing. So, of course, the first instinct is, what do we do in this situation, right? Are we going to a local courts? Does it really work? And if it is the only option, how do we go about it? And it almost seems like the question becomes, how do you, at the start, right, of your venture, make sure that you protect your global asset in a way that provides you maximum leverage and maximum options, right? 20 or 30 years ago, going to your diplomat or to a Department of State or Ministry of Foreign Affairs might have been the best option if you're dealing with a foreign jurisdiction, or going only to the local courts. But today there are better options, and many of them have been utilized quite significantly in the last 15 years. And one of the options is, of course, the arbitration under the international investment treaties, which Natasha touched upon, and I will describe now. So one of the things to keep in mind is, when you are considering a claim under the International Investment Treaty, you also want to consider what are the details of this investment treaty. If I could go to the next slide, if you could go to the next slide, please. How do you make sure that you utilize this investment treaty in a way that you get it right and not minimize your chances, right? So a lot of times when we structure the investment, we do not think, well, what will happen if things go wrong, right? That's not something that is first thing in mind for the people who are thinking about the revenues when you're trying to make a successful venture. So considering this at the beginning and looking at what would give you maximum leverage, obviously looking at the jurisdictions that provide most favorable environment for your investment, the host country, right, for every component of the project, is a nuance that should be carefully considered. So obviously the question is, how do you structure investment as you're going into the jurisdiction where you're starting your operations in a way that gives you maximum benefits? So one of the steps to consider is to look at what this jurisdiction, what kind of investment treaties this jurisdiction is a party to, and what investment treaties you could really consider. If you could go to the next slide, please. So what are the investment treaties? Investment treaties are a particular kind of international agreement, right, between the states. These treaties provide basic protection for investments made by nationals of one state in the territory of the other state. And the type of treaty was originally conceived actually in 1960s as a way to supplement public aid to countries by promoting private investment. Obviously, a problem with attracting foreign investment to such countries was essentially a question of considering what are the local laws, how do you make sure that you diversify your risk, right, as you bring in the capital. So investment treaties provided this kind of a prepackaged solution to those issues. They stated a series of fundamental protections for foreign investments that essentially, being embodied in a treaty rather than national law, could not be changed at once, right? So to supply an alternative to local courts, for instance, the treaties provide for international arbitration of dispute about, whether essentially an host state lived up to the obligation under this treaty. And essentially, in a significant innovation, they allowed for an investor to initiate and control the arbitration without having to rely on a state or any other parties to move forward with the case that it has before it. So as you can see on the slide, there are over 3,000 investment treaties in force in the world today. And most of these take the form of bilateral investment treaties, treaties between two countries. Some, however, as Natasha already mentioned, are multilateral agreements that involve 3 or more countries, and each of which include investment chapters. So what do these investment treaties cover? In general, those investment treaties cover investments by an investor of one country in the territory of another country. So investment is often broadly defined to include any kind of asset. So locally incorporated companies, shares of stock, bonds, contract, tangible property. They often provide example of investment under the definition of investment, depending on the language of the treaty. So to be covered by a treaty, an investment in one country must be owned by an investor of the other country. So such an investor is typically defined to include nationals of the other country and companies organized under the laws of that country. So many investment treaties cover investments indirectly controlled by investors of the other country. So, for example, if you look at the screen at the next slide, please. You have, for example, corporations that hold a controlling interest, right, in a company that in turn holds all of the shares of the company, for example, in Tanzania, for instance, right? So the French company, in the example that we have before you, indirectly controls the shares of the mining project in Tanzania, even though it's done through the investor subsidiary via Mauritius. Why are we looking in this situation? Because if you are, for instance, a French investor going into Tanzania and you do not have an enforceable or an bilateral investment treaty that is enforced that allows you maximum protection, you could consider creating a subsidiary, for example, subsidiary in Mauritius, just to pick up on where Natasha left off, is one of the favorable jurisdictions. So you could potentially bring in a protection under the Mauritius-Tanzania Treaty because you are given an opportunity to have the protection under that particular treaties. So those the Tanzania project, the mining project in Tanzania, and the company assets would be a covered investment under the relevant treaty and allow you as an indirect owner to potentially seek protections. So this example is just to say that just because when you are coming back to the first point that I made, looking to structure your investment and you do not see, for example, a treaty that could give you a maximum protection in the jurisdiction where you're going to, you could carefully consider options under the other treaties, because as we said, there are over 3,000 treaties. So as I explained earlier, as I also explained, there is a considerable variation in terms of the bilateral investment treaties negotiated by different countries over the past 50 years. However, there's a certain handful of provision that is sufficiently common that their absence in a given bilateral investment treaty is more remarkable than their presence. So these provisions are briefly described on the slide before you. So for example, if we go to the next slide, please, and I'll come back to this in a moment. So for instance, there is a national treatment obligation, right? Obligation of national treatment is quite intuitively that the state should treat investment covered by the treaty no less favorably than comparable investment owned by nationals of the host state. And the national treatment obligation is typically subject to a number of specific exceptions, as most states provide in certain sector special treatment for national, for example, fisheries or political activities. But mining activities, of course, are not something that is, in most instances, is subject to the exception. Another type of protection under the investment treaties is the most favored nation treatment. Most favored nation treatment equally intuitively requires treatment of covered investment that is no less favorable than that provided to comparable investment owned by nationals of other countries. There is another aspect to the most favored nation treatment, and it is less intuitive because a lot of times this treatment encompasses provision in investment treaties with other countries. So depending on the language of the most favored nation clause in a given treaty, an investment covered by one bilateral investment treaty may be entitled for the benefit of a better deal that a third state struck in a different BIT with a host state. So in a sense, that provision, if, you know, as you study the investment treaty, as you structure investment into a certain jurisdiction, this clause in a treaty can therefore, in a sense, serve as a sort of a choice of law clause that enables the investor to choose from the bilateral investment treaty of the host state the most favorable legal obligation covered by the clause. Another protection that is very frequently, you know, found is the protection against the expropriation, essentially provision that recognizes the state's right to expropriate property for a public purpose, but only on payment of compensation. So such compensation is often defined as a fair market value of the investment just before the date the expropriation was announced. So significantly, indirect expropriations, those where the states, for example, acts effectively remove any value of the investment to the investor, but without formal decree of expropriation, is generally explicitly encompassed by the obligation to pay compensation. So obviously pretty general and broad requirement for the state to comply, at least in the majority of the existing treaties. Fair and equitable treatment is another typical protection that is offered to the investors. The precise content of fair and equitable treatment is subject of debate. Some commentators and tribunals apply it sort of I know when I see it standard based on whether the treatment seems fair or unfair. Others consider fair and equitable treatment to refer to a long-standing and evolving standard of customary international law. There's also full protection and security that you see on the screen, and it often understood to refer to principles of international law requiring a minimum level of police protection for foreign property. I should note here that the fair and equitable treatment is being redefined in a lot of newer generation of treaties that states are currently renegotiating with each other to make sure that this concept of what constitutes violation of fair and equitable treatment, which is frequently found in those treaties, is clearly defined. So if we could go to the next slide and kind of cover briefly, in the interest of time, the points that were mentioned. I think the question always comes from the client is like, well, how those investment treaty protections enforced, right? What do we do? Investment treaties are part of this rare class of international agreements that grants companies, as opposed to states or intergovernmental organization, a direct right to enforce treaties terms in an international forum, right? So the means of dispute resolution provided is arbitration, and that's one of the clauses in most of the investment treaty treaties. So in many respects, the process for resolving these disputes resembles that of the international commercial arbitration, which I'm sure a lot of you know. There are, however, certain important differences, right? First, and that's something to keep in mind, is of course the applicable rules, right? The investment is often given a choice of arbitral rules to invoke to govern the disputes. So arbitration rules most often made available under the investment treaties are those provided by either the ICSID Convention, which is the Convention on the Settlement of Investment Disputes, or the ICSID Additional Facility Rules, or the UNCITRAL Arbitration Rules. So second, another point that's to keep in mind is that the parties to the dispute are different from the typical international commercial arbitration. They consist of the foreign investor as claimant and the state itself as a respondent, right? And importantly, third, the applicable law is different. Most important from the investor's perspective is that applicable law for the treaty breach is not that of the host state, although the host state's law often forms an important part of the facts of the case. Rather, the applicable law for a breach of an obligation set out in the treaty is a public international law. And public international law is a specialized area, and it is the one in which the sources of law are not essentially only rely on the domestic law. So like international commercial arbitration, successful investment treaty arbitration generally result in an award that is enforceable under the terms of either New York Convention, if it's the ancestral arbitration, or the awards that are enforced under the self-contained system of the ICSID Convention. So when you obtain an award, one of the things that you want to keep in mind is that there are options to potentially negotiate settlement with the award, seize assets abroad, or there are many secondary markets for the award. So essentially, the options do not end in the sense that once you obtain an award as an investor, what do you do with this? At this point, there are options that allow you to, again, maximize efficiency and minimize the risk. Joseph, over to you.
Thank you. Most educative. And just on that point, I know I had quite a bit of questions for you, but we need to move to James. But I just wanted you to, just one quick question. There's a wave of resource nationalism going on, and I think there's quite a pressure on governments to, increase state participation or revise mining code. I think we're also seeing a lot of local content legislation. When does that cross the line, to you in terms of moving that to treaty breach? If you could answer that quickly before I move to James, so that we can cover him as well.
Thank you. I think the most important point is that international investment law does not prohibit states from regulating their natural resources sector, right? In fact, tribunals consistently recognize that the state retains sovereign authority to adopt policies in response to economic, political, environmental, and social pressures, right? The difficult question is where the line lies between the legitimate regulation and conduct that violates treaty protection, such as, for example, that I mentioned, fair and equitable treatment, indirect expropriation, and umbrella clause. I sit on the ancestral working group theory, and I can tell you that this is something that states actively discuss. They question the extent to which the regulatory framework can extend. And I think what recent African mining dispute demonstrate is that the tribunals increasingly focus less on whether a state changed its policy and more on how it did so, right? We're seeing a lot of tensions emerge across Africa. I mean, we've seen in Tanzania reforms that are a good example where the government introduced changes that increase state ownership of right and negotiation power and restriction on international arbitration and natural resources contracts, which states absolutely have the right to seek, right? However, the question becomes, how do you make sure that you comply with your obligation under the treaties? I think another thing that is very important to keep in mind is that the tribunals have become increasingly attentive to proportionality. And one of the investment cases that comes from a different continent, from South America, famous Bear Creek versus Peru case, where a tribunal acknowledged that Peru's genuine public order concerns and social unrest surrounding the project, and however still found that the revocation of the investor's decree in that mining project constituted unlawful expropriation because the state's response disproportionately extinguished the investment without adequate compensation. So there are a lot of different trends that are important to keep in mind. And we are obviously keeping track on all of them because essentially the states are introducing a lot of regulatory changes and they're moving quite fast. So the future mining disputes, and it looks like where a lot of the future mining disputes in Africa are headed. Thank you, Joseph.
All right. Okay, thanks, Diora. James, very quickly moving to you. James is from our UK office, particularly based in London. He'll be speaking to arbitration's do's and don'ts, practical lessons for investors. James, you're the last man standing. If I could quickly hand over to you and you go over. I know we might have to go back a couple of minutes, but I'm sure you'll be able, with your experience, walk us through the do's and don'ts and the practicalities. Over to you, James.
Thanks very much, Joseph. So yeah, in the time available, I'm just going to touch on a few practical tips if you are in an arbitration context. I'm going to say something about disputes with states, because of course inherent in what we've been talking about is that if you're on the investor side, your claim will be against a state. And then we may have time very briefly for some lessons from recent cases. So if we can move through to the next slide, please. As we've talked about, the arbitration agreement, if it's in the context of a treaty, you will have no ability to control it as the investor. You have what's available to you. The one point I would pick out, it obviously is possible for investment protection to come in the form of a contract, in which case you may have more negotiating ability. The one point I would pick out from this slide is the question of the seat of arbitration, because in my experience, a treaty may provide, for example, for uncitral arbitration, but may not provide a seat, and the seat is of critical importance in any arbitration. It provides the jurisdiction, the courts of which have supervisory jurisdiction over the arbitration, and it's really important to get that right and choose a jurisdiction which is pro-arbitration. But I'm not going to say too much more about that. If we could move on to the next slide, please. And then this really is about you're an investor, you have a potential claim, and how does that move forward? Well, the reality is you are in control unless there is a time limit provided for which you're up against. You essentially have control over when you commence the claim, and therefore it's essential to be prepared. And there are lots of things that you can do to make sure that you're in the best possible position going into your arbitration. On the slide, and I haven't got time to go through all of them, are some of the key things that you need to be thinking about. But obviously, pulling together all of the relevant documents, you may well be relying on quite a number of them in framing your claim at the outset. If you have witnesses that are witness to the various events that have happened, you will want to have spoken to them, actually have some sort of a draft statement from them and have that ready to go. You will obviously need to have appointed lawyers, ideally have had an assessment of the merits. There may well be a question of funding in the background to that. I think of crucial importance as well is having on board already, although your expert evidence may not be deployed at the outset, knowing which experts you're going to need. In a mining context, that's going to be a quantum expert. You may well need a pure mining expert, a mining finance expert. There may be a number of others that come into play. Having all of those lined up will be of critical importance before you commence your claim, so you know precisely where you're going. And obviously, it may be that your treaty has a number of pre-action requirements to comply with. So that's all absolutely critical. And then if we move forward to the next slide, please. Being realistic about how long this is going to take. Investment arbitration, 3-4 years. Cases do take longer than that. It's not going to be cheap. The costs are significant. Be really clear that this is the route that you want to take. If there's another route, obviously there may be some scope to resolve the dispute with the state. I mean, there is a third way, which is that most cases do settle, and so it is possible that you start an arbitration with the view that that is applying pressure to the states and hoping to achieve a settlement along the way. But I think being really realistic about how long arbitration takes and how much it's going to cost, and making sure that you've got the internal management time to be able to deliver that and the funding to be able to fund it is going to be really important. If we can move through to the next slide, please. Again, this is it's a core point, but you are going to have some ability to choose your arbitral tribunal. Typically, you will choose one co-arbitrator, the state will choose the other, and there'll be some ability to input into the appointment of the chair or the president. Really, you can't do too much due diligence on the right arbitrator, thinking not just about, and we now have a large number of decisions in an investment context, and importantly, I think in a mining context. So you can see how arbitrators have decided certain cases. Really, we have lots and lots of tools now to be able to be really clear about if there is a side that an arbitrator tends to take pro-investor, pro-state, being really clear about, the tribunal that you're appointing, and also the dynamic that that there will be between the members of the tribunal. I think that last point on this slide is key, making sure they've got sufficient time for the disputes so that you really get their full attention during the course of the arbitration. So I wanted to say something about managing disputes with government and state entities. We act on both the investor and the state side, and we have real insight, I think, into some of the challenges on the government side, which you as an investor may well want to think about quite carefully. It depends, of course, which government is involved, which state is involved, but you will very often get internal divisions between the regional or the state government and the central government, and there is always bureaucracy within the government, which often means the governments are slow to respond. You will often find, for example, that governments are not in a position to appoint an arbitrator, to nominate their arbitrator within the relevant period of time. Can you exploit that? Once you are looking at an arbitration scenario, you want to take every tactical advantage that you can, and it may well be that trying to push things forward with a quick procedural calendar is in your interests and difficult for the government to deal with. Could we go to the next slide, please? So this isn't always the case, but some governments don't appoint external lawyers at all. Some do, but they do so where the rates are low and they have limitations in terms of their budget. Again, there may be an extent to which you as an investor can exploit that, and it may be that, for example, you can make the proceeding look very long, very expensive, very difficult to defend, and that can be some leverage in terms of trying to achieve settlement. So there's a few lessons there. I don't have too much time to spend on the remainder of the slides in this section, but this is another tactical issue. Governments, of course, in principle, have control over all of the documents across all of the government, all of the ministries, all of the government agencies. That's a difficulty for them in terms of the disclosure and the document production process in the arbitration. Again, can you take advantage of that? And then importantly, I think Diora touched on this, settlement is in many instances the best outcome for an investor and the most realistic means of achieving an early resolution of the disputes. From a government's perspective, it's quite different to commercial arbitration. Many governments find it difficult to settle disputes, not because they don't want to, but because the process of actually getting to a point where you can agree usually to spend an amount of money to pay an investor or to find a way to allow the mining project, for example, to move forward, is very difficult in a democratic process to get through the parliamentary approval process. Bear that in mind in terms of whether or not it's realistic that your case may be resolved. Joseph, I am conscious of time, and I don't know if there are questions in the chat, but it may be that I stop there just to leave a minute or two.
Yeah. Well, at the moment there's no questions that I can see in the chat, but perhaps while you're on the floor, James, I know you had to rush through to be with the time. Just one question for you. Are you seeing clients choosing international arbitration as a preferred route for dispute resolution from your experience? Well, we wait for people to pop up questions in the chat. James?
Yes, and I think this was touched on before as well. The reality is that arbitration is still often better than the court route, including from an enforcement perspective. It may be the only means of enforcing your award or your outcome. And although there are lots of grumblings about how arbitration could be improved, and people that do find it expensive and time consuming, I think it remains the optimal form of dispute resolution, and indeed, particularly in an international context like the one we're talking about, probably the only one that's really viable for investors in these projects.
Thanks, James. Just one last question, James, since I can't still see any questions in the chat as we wrap up. Are there any lessons, trends emerging from your recent mining sector questions that you think investors should be aware of, James, very quickly?
So, I mean, this was just one thing I was going to touch on in my slides is I suppose one of the big differences between treaty arbitration and commercial arbitration is you almost always have a state raising jurisdictional objections in a treaty case. And I think being really clear about what the viable objections are on the government side and how strong those might be, how those may delay the process or even give rise to sort of parallel court procedures is really important. And I think having clarity on that, guided by your lawyers at the outset so that there are no surprises, I think is really important.
Thank you. Thank you, James. Thank you, Diora. Thank you, Natasha. We are on the top of the hour. It's 4 p.m. Central Africa time. Just to thank you. Unfortunately, we have to wrap up. As you can see, there's so much to be said. Perhaps next time we'll consider extending it to about an hour and a half. But I think thank you very much for the insightful presentations from all three of you. We have recorded the session, and so if you did register, you should have the link to be able to play back this particular webinar. And if at all there's any other questions you have, please feel free to get in touch with any of our presenters. If not, feel free to send them out to me and I'll send them out to them. So I think thank you very much for this particular session. Please look out for other upcoming webinars that the Dentons International Arbitration team will be doing. And please, if you have any issues, any matters that you need, please feel free to reach out. So on that note, I'd like to thank everybody, Khalil, Chama, Mika, who've been helping me in the background. Thank you very much. And please have a good afternoon, morning, or evening. Thank you.